play between these three different pillars. Now, of course, no one who exercises power is pleased when that power is challenged. Some degree of tension between Parliament and the judiciary is normal, as is the case with the executive branch of government. Yet in today's polarized world, what should be a healthy tension is sometimes amplified beyond proportion. We see political leaders speak publicly without restraint against judicial decisions that don't go their way. At the IPU, we increasingly see situations in which the work of Parliament or individual parliamentarians is made difficult because they are subject to politically motivated legal proceedings. These examples not only show the importance of making sure that Parliament and the courts act responsibly towards each other, they also underscore that we cannot do so without taking into account the role of the executive and the media. Ladies and gentlemen, parliaments have a critical role to play to safeguard the independence and the effectiveness of the judiciary. Parliaments should put in place legislation that ensures such independence, for instance, when it comes to the security of tenure and the appointment of judges. But Parliament's responsibility goes well beyond that. They can help ensure that laws and policies are in place and implemented that ensure access to justice for all, and that legal procedures follow due process. These are no hollow words at a time when human rights are again increasingly being traded off in the fight against terrorism. Tonight we will hear more about specific examples of parliamentary engagement in support of an independent judiciary. Tonight we will also hear about the challenges that arise when Parliament and the judiciary are at loggerheads, either because of different interpretations about the boundaries of their respective powers, or because either or both institutions fail to function properly, or because they can simply do better. Here too, it's important to think of solutions that can address problems when they arise, or better still, that can prevent them from occurring in the first place. By way of example, parliaments can do much better at verifying that bills are in conformity with the Constitution. This in turn will reduce the risk of legislation being struck down by the courts. As a result, possible contentious confrontation is avoided. But when it's too late and when tensions have already come to the fore, there may also be ways to mediate between parliaments and the courts. For instance, in legal systems where there is an attorney general, that entity, if trusted by both sides, can give an opinion on issues of conflict and play an intermediary role between Parliament and the courts. Mutual respect between Parliament and the judiciary should go a long way towards overcoming differences and accepting the very idea that each can hold the other to account. Tonight's discussion will look at specific examples to channel tensions effectively between parliaments and the courts. Tonight's discussion should also provide examples that will help reduce the risk of judicial and parliamentary overreach and enforce accountability of both institutions. I personally hope that the panelists will also address these issues against the backdrop of the heavily polarized and volatile political context in which many of us live. As a result, it has been increasingly left to the courts to act as the ultimate protector of the constitutional order, and often as an arbiter on moral and political controversies, even when such controversies should have been settled in the political arena. I look forward to hearing more about these issues from our distinguished panel and from the interactive discussion with the public. With these brief remarks, I wish to give the floor to Ms. Irene Khan. Thank you.
Okay, good. Yes, it's on. So thank you very much, Roger, for your few words. Now, we have, as you see, a very distinguished panel here. Before I introduce them, let me just say 2 words about my own experience as the head of IDLO. We work on the ground. We work on the ground to empower people and to enable governments to reform laws, strengthen institutions, judicial and legal institutions for peace, justice, and sustainable development. 3 weeks ago, I was in Nairobi in a room in an open tent, actually, about this size, with about 5 times the number of people, and with the Chief Justice of Kenya, with the Attorney General of Kenya and with the entire Kenyan judiciary there. And the purpose of that event was to launch a report that we had written based on our work over the last 5 years about the judicial resolution of electoral disputes. Now, Kenya is a country which you will remember in 2010, just after the elections, had suffered enormous bloodshed, conflict, and strife precisely because the political parties did not trust the results, but they did not trust the courts to go and resolve their disputes. That then led to a reform of the Kenyan constitution. My organization participated and assisted in that reform, and it led to a major reform of the judiciary, a vetting of all the judges, and appointment, fresh appointment or new appointments, including of a Chief Justice who came from outside the judiciary, was interviewed in public, and was then appointed as the Chief Justice. And there were a number of major transformational changes that were brought into the Kenyan judiciary. One rather interesting thing they did was they did away with wigs because they wanted to feel closer to the people. And wearing the old, British-style wigs just created remoteness between the judiciary and the people. They then had elections, as some of you will recall, in 2015, where there were disputes, but thanks to the reforms of the judiciary, thanks to a lot of the capacity development work that we had done with them, they were able to resolve all the judicial disputes, and there was no violent reaction, including over a very controversial decision according to which the current president, then the presidential candidate Kenyatta, was allowed to participate in the elections even though he had an indictment before the International Criminal Court. And the judges, the Supreme Court of Kenya, the High Court, the most senior court of Kenya, came to the conclusion that it was appropriate under their constitution for him to participate in the election. Despite that very controversial decision, there was no violent reaction. Kenya is now preparing for another election in August, and we have been working with the judiciary in ensuring that, once again, if there are differences of opinion, it will be resolved peacefully through judicial means. So this, to me, is a very interesting case, that the judicialization of politics should not lead to the politicization of the judiciary. It's a major challenge, and it's precisely on some of those issues that we will be listening to our panelists today, mainly on the special separation of powers between the judiciary, the executive, and the legislature, and about building people's confidence in the courts. What are the issues of independence, integrity, approach, and principle and ethics that builds people's trust in the judiciary? Now, we have on our panel, of course, the special rapporteur for the independence of judges and lawyers, who is well known to many of us, of course, Mr. Diego Garcia Sayan, who is the former president of the Inter-American Court of Human Rights. He was also the former Minister of Justice of Peru during a period of transition, as well as its foreign minister. Mr. Garcia Sayan has been the special rapporteur since last December, and this morning he presented his first report to the UN Human Rights Council. Next to him is the Honorable Najit Bensala, who is head of the International Cooperation of the Ministry of Justice and a judge of the Supreme Court of Tunisia. And next to her is Professor Nico Krish, who's well known to many of the students here, of course, as Professor of International Law at the Graduate Institute here in Geneva. And on my left, I have Lady Justice Lillian Ikiri Kubinza, who is a Justice of the Supreme Court of Uganda. And next to her, Mr. Murray Hunt, visiting professor of human rights law at Oxford, but also the legal advisor to the Joint Committee on Human Rights of the UK Parliament. So we have a very gender-balanced panel here, as you can see, but we do have another panelist, and that is Dr. David Sedoff, actually a PhD, who got his PhD from this graduate institute not so long ago. He is now the executive director of the Center for Ethics and Rule of Law at the University of Pennsylvania, and a former government official of the US government, who will be joining us by video link. So we have a full panel, but I hope it will be an interactive session where panelists will give short responses in the hope that you, the audience, will join in, ask questions, make your comments. This is an extremely important issue, as we have seen the link between democracy, rule of law, independence of judges and lawyers are interlinked, and they underpin the infrastructure on which human rights are based. So let me start first with the special rapporteur. Sir, we of course have in this audience some lawyers, but we also have non-lawyers. How would you define the independence of the judiciary in terms of the key principles? What are we really talking about here? And what did you say to the Council this morning about how your mandate and your predecessors who worked on this mandate, what have they done to advance the independence of judges and lawyers, and where are the challenges?
Well, good afternoon to everybody. First, really thank you for the invitation to be with all you this afternoon. I'm really glad to be here and proud. That my first day in my presentation in the morning, and right now I'm supposed to make a brief summary in 3 minutes. Let's see if I can do it. Because really, independence, when one imagines an independent judiciary, the first reaction, and it has sense, is independence regarding power, independence regarding political power, as well independence regarding economic power, and now on, independence regarding extra-legal powers like organized crime or criminal groups. But being here with the Inter-Parliamentary Union, perhaps the main question is, how does this independence regarding Parliament works? If it works at all. Permanent cooperation or permanent conflict? That's a big dilemma. And perhaps there is a mixture of both. Why? First, because a mixture of diagnosis, 2 or 3 things which are important, and ideas of how things can eventually work. First, Parliament is one of the major expressions of political power. So if there is a possibility of tension and cooperation with political power, it is mainly with the parliaments. In some countries, it depends. It will be with the executive. But if it is with the parliament, it has to do with supervision, with the selection process, in which, in many cases, not only in the so-called third world countries, there are many ways of intervention from the parliament, so to investigate, dismiss, control. That's a permanent temptation. So how this connection, which is essential in any democracy, can work? In a sense that it depends of control by the public, full information in which a judge is being investigated by the parliamentary commission that has some sense and not a kind of political revenge. That's a thing that in a case by case can be distinguished. Second, a thing which is very sensitive in many countries, which is a question of budget. The budget is decided by the Congress, by the parliament. Until what extent, not only in the sense of the amount of the budget, there is a permanent tendency in Latin American countries to fix a percentage of the national budget oriented to the judiciary in the constitution. That hasn't worked, because that depends of the capacity in the judiciary itself to handle its own budget, to orient it appropriately, not only to increase salaries of the high-ranking judges, but eventually to increase and improve the deployment of the judiciary all around the areas, especially rural areas. So how this big tension is handled in a sense in which that is referred not only to the political decision of the parliament, but the political quote-unquote decision inside the judiciary to handle this budget in a sense that really approaches justice to the public and not only concentrates in fancy buildings in Mercedes-Benz and in only high salaries for the judges. Second, a very sensitive matter, which is, you mentioned that, Roger, in your presentation now. Who is in charge of innovation and of changes, substantial changes? I won't fully agree with your approach in which that should be dealt by the Congress. Why? My experience, our experience in many Latin American countries regarding the improvement and modernization of legal interpretations in the last 10 years has been that while the Inter-American Court of Human Rights was enacting rulings, really innovative rulings regarding several matters, the best connection to follow up with that evolution had been, in all cases, the high courts in Latin American countries. So while a ruling was taking place regarding collective property for indigenous peasants, other that has to do with confronting discrimination because of sexual orientation, and so on and so on and so on, all that major improvements, with some exception, came from the Inter-American Court that were received not by the Congresses, but by national courts, in which eventually the second step was taken by the executives, and the most slow one to understand that they should change regarding, for instance, amnesty laws, the so-called self-amnesty laws that have been expelled by the national legislation, by the Inter-American Court, that was in a way implemented by national courts, by governments, but with big reluctance by Congresses. That's Latin American phenomenon, I don't know, but that has been the case. And last, and with which I finish, Irene, looking to the future, one of the major challenges, again, the matter I mentioned this morning in my report, major corruption and organized crime as a major challenge in which perhaps we find there a terrain for a fantastic possible cooperation between judiciary and Congress. Because if we follow an innovative approach in which is not question only to react against corruption, but to use, reinterpret, and implement fantastic international provisions like the UN Convention Against Corruption, that has to do, if you read it once, it's easy from Article 15 on, it has to do 100% with the things that judiciary should do. But 20% of the convention are things or legal provisions that must be written and adopted by Congresses, which is not only a question of actualization, but a question of changing the approach in which the way to respond to the problem of major corruption and organized crimes has to do mainly with international cooperation. International cooperation that at this stage, at least is the case now in Latin America, so to deal with big cases of corruption, is working, I won't say fantastically, but it's working when it is the cooperation between judges, between prosecutors. But again, the speed in which the Congresses are following this requirement that we need to catch with this UN Convention Against Corruption, they are really looking backward. So, finally, this tension has to do with principles, but this tension at the same time has to do with legitimacy. And in a context in which it seems that in some cases, because of different peculiar circumstances, the judiciary seems to have understood better its role. Maybe one big question is what is happening, so we are not hearing a kind of choir or symphony, but two different voices with two different tunes. That eventually can be discussed. Thank you.
I I recall from the report that you submitted today, which actually really summarized the work that has been done since the mid-90s by various special rapporteurs with your mandate, that this issue of different actors, if all the actors play their role accordingly, that's when the independence and integrity of the judiciary can be maintained. Now, you talked about resistance and courage by the courts and leadership, and on the other side, the opportunity as well to cooperate with Parliament. Now, following this line of courage and leadership of the court, I would like to turn to Lillian and ask you, Lillian, you're a sitting judge, senior judge in Uganda, and the kind of cases you have had to handle in a country where, if I'm quoting your president correctly, he once said that courts should deal with the theft of goats and chickens and leave matters of national interest to one side. Now, you were involved, in fact, you wrote the lead judgment in a case in which you actually challenged, the court challenged and set aside a decision by the president on the appointment of an interim chief justice. Maybe you could tell us a little bit about the real challenges that a sitting judge in Africa faces in making real this principle of an independent judiciary.
Thank you very much, Irene. In 2013, I was appointed to the Constitutional Court of Uganda, having spent all my time as a teaching academic at Makerere University. 6 months into appointment, a petition was brought to the Constitutional Court in which a member of parliament, incidentally, was challenging the appointment of a chief justice by the president of the country. When you look at our constitution, there is a Judicial Service Commission which has a role of interviewing potential candidates to join the judiciary. And the Judicial Service Commission sends names of candidates, potential candidates, to the president of the country. The president selects names which he then sends to Parliament for approval. In this particular case, a Chief Justice had attained the age of retirement. He had attained the age of 70 years, and according to the Constitution, he was expected to retire. What the president did, actually what the Judicial Service Commission did was to interview several candidates. They picked a name of an individual, which I think 3 names, which they sent to the president so that he could pick his choice. The name of the Chief Justice who was to retire was not on the list, precisely because the Constitution was clear that at the age of 70 years, you retire. What the president did was to send back the names of the people who had been suggested. And the document which he wrote said, in light of the fact that we do not have enough people with competence or experience, we need actually to use more and more of these people who have been in the judiciary for, and gained experience. And he therefore said that even if I actually appreciate the names of the candidates you sent to me, I find it appropriate to make best use of a person who has been heading the judiciary for years. I therefore appoint Justice Bernard Odoki to the position of acting Justice of the Supreme Court, but also acting Chief Justice. The Judicial Service Commission has as one of its members the Attorney General, who is actually the chief legal advisor of government. The the members of the Judicial Service Commission wrote back to the president and said this would be unconstitutional because looking at the Constitution and its provisions, somebody who has already attained the age of 70 cannot act. There is no provision for acting Chief Justice. Unfortunately, the Attorney General, who is actually a member of the executive because he's a minister, had a minority view and wrote to the president and said, it is possible for you to reappoint a person who has already retired as Chief Justice. And it's within that context that a member of parliament, when they sent the name to parliament for approval, the member of parliament brought a public interest litigation case saying that this would go against constitutionalism and the rule of law. So when the case was brought to the Constitutional Court, a panel was appointed, but there were changes. The Deputy Chief Justice changed panels several times, and off record, the Deputy Chief Justice, who actually heads the Constitutional Court, wanted the court to go according to the whims of the president. It so happened that he became ill and went to India, and I think there was as good as a coup. The head of the most senior judge then set up a panel, which I was on. We looked at the Constitution and we recognized that this would be unconstitutional. So I wrote a lead judgment where I analyzed what judicial independence is and analyzing the principle of separation of powers and the role of the Judicial Service Commission on the one hand, the role of the president on the other hand, and the role of parliament. There was a dissent judgment, but the majority of my colleagues agreed with my judgment, and we actually put a stop to appointing a person who, according to the Constitution, could not be appointed. What were the challenges? Or maybe the good side of it is that sort of the legitimacy of the judiciary could be seen by the way the public reacted. Not that we did it in order to please the public, but it was clearly unconstitutional. And what happened is later on, I was actually promoted to the Supreme Court, which was actually, again, it's the president who appointed me to go to the Supreme Court, which shocked the public because everybody had thought that that would be the end of my career. Thank you.
I should have added when I introduced Lillian that she has a CV full of firsts. She was the first Ugandan to be appointed to the senior judiciary without having gone through the judicial system. You came from academia into that. She was also the first, I think, Ugandan to get a PhD in law, and the first to become a full professor of law in East Africa, the first woman. So there are many firsts that she has, including having carried out such a judgment and having benefited from it. Okay, now, if we could spend a couple of minutes on this issue of appointment, because this appointment and removal of judges is a highly political process, even in developed countries. And I'm wondering whether we could go to Dave Sadoff, if he is linked with us. Dave, in the US, you've just had a new appointment to the Supreme Court, and the US, the world's oldest democracy, has a very politicized system for appointment of judges. So how do you maintain the separation of powers in that kind of a system where judges have to be elected or confirmed by a political body? And we've seen the process now with Justice Gorsuch And of course, my next question to you, if you could answer that at the same time, is, what do you see, what are some of the risks to judicial independence given the current political climate in the US? Dave, are you there?
You hear me okay?
Good. Did you hear me?
I heard you fine. Can you hear me okay?
Yes, we can hear you fine. Please go ahead.
Okay, good. Well, first, let me thank you and all the sponsoring organizations for inviting me to participate in this forum today. And thank you in particular, Irene. What you didn't say when you introduced me was that I once worked for IDLO as general counsel until just a few years ago. And I'm happy to be back working with IDLO again. Let me take a few minutes to talk about the extent of the politicization of the judicial appointment process in the U.S. federal judiciary. I think there are a few incidents or trends that are worth flagging by way of context to sort of how did we get to where we are today. I think one of those instances was the Roe v. Wade Supreme Court judgment of 1973 that recognized the right to abortion. A number of conservative political conservatives in the United States were very unhappy with that decision. They felt that the court was taking a kind of a judicial activist role, and they resented it. And that was one important data point. Another one was in 1987 when President Ronald Reagan nominated a guy named Robert Bork to the Supreme Court. That confirmation process, which I believe involved more than 100 witnesses and over 30 hours of testimony before the Senate, was an event that really polarized the country, partly because it was viewed as having been really a vote on his judicial ideology, and as opposed to his fitness to serve as a Supreme Court justice. And the third trend I would note was just a polarization generally in American politics, where the extreme left and the extreme right have kind of pulled the center away and left it more vacant in the middle. And I think that also has contributed to this politicization. So where are we now? These days, loyalty to political party is more important, I think, than the priority given to merit. Political parties do play a significant role in helping to select a judge. Now, we have the district court judges at the trial level, the appellate court judges at the circuit level, and we have the Supreme Court justices. And in all of those cases, the political parties play a significant role. The president will typically consult with the senators from his or her political party in deciding who to nominate, because he knows that at the end of the day, the Senate is going to have to confirm that person and wants to make sure that they're going to be on board. And it turns out that more than 90% of those people who are nominated to the Supreme Court share the same political party, at least nominally, with the president who appoints them, which is a high percentage. That said, and by the way, I would say that one of the the way it works today is that those nominees are selected largely because they sort of fulfill certain, or they meet certain, let's call them political litmus tests. They tend to have sort of the position that the president wants on those hot button issues of abortion or on same-sex marriage or gun control or those kinds of controversial issues. That said, according to legal scholarship, there really is there's a clear, but it's only slight correlation between what the judges are, how they're ruling, and the part from which the president was who appointed them to the court. I'll also say that in the Supreme Court, they hear about 80 cases a year on average, and something just short of half of those cases tend to be decided unanimously, and only something less than 10% tend to fall along the political fault lines based on the presidents who appointed them, the parties who appointed them. are plenty of examples of presidents who have been disappointed by their nominees as well, or by their appointees, who haven't sort of, carried the water that they hoped they would. But there's little evidence to show that once in office, once on the bench, that our Supreme Court justices are trying to curry favor with presidents or trying to pay homage to them in the sense of paying back for the special opportunity. Let me now move on to, while I recognize that there's definitely politicization, it's probably not as great a factor in reality once they get into their positions. But it is still a fact of the selection process. What makes the U.S. System work well then in terms of maintaining independence in spite of or despite that politicization? And there are a number of factors. The first, I think, is that the U.S. political system has a certain stability. We have two political parties, fairly evenly divided. If that were not the case, and one party were to have a much greater opportunity to appoint judges and justices to the courts, I think we'd be in a much worse situation. Judges are appointed, they're not elected. If they were elected, they would have to be responsible to raise money, they'd have to satisfy their donors, they'd have to take partisan positions during the elections, and so forth. The appointments follow not only government investigators' careful scrutiny of the nominees' backgrounds, but there's also the American Bar Association Standing Committee on the Federal Judiciary, whose responsibility is to vet these nominees and to actually rate them in terms of whether they're highly qualified, or not qualified. If they're not qualified, it's very, very difficult for the Senate to confirm them. Another feature of the U.S. system that allows for independence is Senate approval.
Dave,
so it's a second.
If you could just round up your comments, and then we'll probably come back to you again.
Okay, I was just going to say, so you have a second political branch that's involved in the process, the public scrutiny in terms of the congressional or the Senate confirmation hearings. Federal judges have lifetime tenure. They cannot have their salaries reduced, and there's self-administration and judicial codes of conduct that also help. Those are features that help to ensure and promote an independent judiciary in the United States.
Okay, thank you, Dave, for telling us about the world's oldest democracy. Now let me turn to one of the youngest ones with very short democratic experience, and that is Tunisia, and to Najat Ben Saleh. A long-standing democracy can withstand these changes and can survive because politics has basically found an equilibrium. What happens in a country in transition like Tunisia? You have been a judge. Now you are a member of the Ministry of Justice. Your country has gone through a period of turbulence and change. So tell us the experience of a country in transition and how the relationship between the judiciary and parliament works on that. And after that, I'll go to Nico and then to Murray. It should be on.
Thank you. First, I want to explain my thanks to invite me to this high-level dialogue. Tunisia is a new democracy, yes, but it's still conducting a difficult process. It's a very special experience, but with many challenges. With many challenges because the turbulence and the politicization of all topics and all things was in discussion. So let me start by saying that independence of justice we're still convinced that is the pillar of the democracy. And it is in the heart of reform of justice in Tunisia. We do many things. We have a new constitution. We voted a new constitution. We voted a new law building a high judicial council. But the exchange with parliament actors still difficult. It's very difficult to exchange and to have the common understanding of what is independence of justice. Because after the revolution, we thought that is an evidence that we have a common understanding of what is independence of justice. But when we discuss the law concerning the matters, we find that it's not an evidence. Many things must be the object of a deeper dialogue to have a faster process. And now we are conducting a new reform of justice with, I bring this document for you. It resumes the reform of justice system and penitentiary system in Tunisia. And this action plan was included in the National Action Plan. It based on many pillars, independence of justice, quality of justice, ethic, many things are in this. And we are working now to the success of this reform. Thank you.
So it's a constant process of reform and change. Now, we are talking of judicial independence as a public good. It's the right thing, it's the good thing. But is there such a thing as too much independence? And I think, Nico, when I asked you what kind of question should I put to you, you wanted to talk about juristocracy. You said that there are some commentators who have raised the issue of juristocracy. So tell me what you actually mean by that. Is too much independence bad, and where do you draw the line?
Yeah, thanks. And first also, thanks for having me on this panel. It's a great honor, really, and great to be on this panel with such eminent persons. Yeah, juristocracy is an interesting concept. It's a concept framed by Ren Herschel, a Canadian political scientist, some years ago, in which he tries to capture a phenomenon that we see in Western Europe and the US, but also in many other parts of the world, is that judiciaries, and especially Supreme Courts and constitutional courts, have gained increasing amounts of power to act as political actors, to interfere in the political system, which is really something that half a century ago, in many places, we wouldn't have expected to be possible. So there's a rise of the judiciary, a judicialization of politics, in a sense, and the possibility for courts to intervene in issues of elections, the relationship between chambers of parliament, between the executive and parliament, but also broader societal issues, abortion and all that is now coming before the courts, where it didn't necessarily arrive in earlier times. And so Ren Herschel sort of traces that process and says, well, so what we're really doing is that we're creating in many issues a government by judiciary rather than by parliaments or executives, and he tries to describe that tension. And there's much to that. I mean, it's obviously, so there's a broader development that we're seeing here, and lots of questions that can be asked about whether that's the right form of democracy that we want, one that we could qualify as juristocracy, or how strong the role of the judiciary should be and how independent they should be, because from the early days when we talked about judicial independence, right, sort of centuries ago, there was an idea of a judge as being a mouthpiece of the law, kind of an automaton of interpretation, right? There's a law and the judge finds what the law means and that's it. Well, we've realized that judges, this is not necessarily what judges are doing, and many courts are, by necessity, engaged in creative interpretation. Typically, a constitution isn't specific, like in your case of the retirement age, possibly, but most of the time it's not specific about many rules. They're vague, open-textured. They may have been written a century or 2 centuries ago, and they need interpretation. And courts assume that role of interpretation and become lawmakers as they do that. And of course, that raises lots of questions of accountability, right? Sort of, if they make the law or they interpret the Constitution and remake the Constitution, how should we hold them accountable for what they're doing? And can we simply let them free, let them be independent in doing so, which somehow, from a perspective of democracy, we would think is a strange position to give to someone who can essentially rewrite a constitution. Right? So there's a tension there. I think there's a very interesting tension that we ought to talk about, in a sense one that leads us to thinking that possibly the politicization of the judiciary that in your opening statement on Kenya you kind of said, well, so we should avoid that. Something that's possibly unavoidable when we think of judges and courts in that broader lawmaking function.
This is, of course, a very interesting issue of judicial activism. Do judges simply interpret law, or do they make law? And especially those of us who are coming from the common law tradition, I think on this side of the panel and Dave behind us, tend to go along with the idea that judges actually create precedent and the precedent becomes law. And I come from Bangladesh. Right next to me is India, where, as you know, the Supreme Court of India has read one small provision called Principles of Social Policy in the Constitution to issue a whole range of decisions on economic and social rights, giving people the right to housing and right to jobs and right to many things have been read into it, including public interest litigation. The right to public interest litigation has been read in through judicial decisions. So there is, where does one draw the line between parliaments and the judiciary? What would you like to say on that, Murray?
Thank you very much, Irene, and thank you very much, IDLO and IPU, for the invitation to take part in the panel. Very, very pleased to be here and part of such an interesting conversation. Where to draw the line is a very, very difficult question. I'd like to begin, if I may, by responding to Nico's very interesting observation, because for me, the answer to this question, why should parliaments care, is really because of exactly what Nico describes, which is this very pervasive sense today in many countries, I think probably across the world, that there is some sort of democratic deficit in our institutional arrangements for protecting human rights and the rule of law. There is a very profound and quite corrosive concern in many countries, including my own, the UK, that judges have simply gone too far and have got beyond themselves in terms of getting involved in political disputes and political arguments. And this is, I think, a concern which we need to address very seriously without necessarily accepting that it's well-founded. It's a very real concern that we need to address. And so for me, the most important reason why parliaments should care about judicial independence is precisely in order to respond to this concern about there being a democratic deficit in our arrangements, in our institutional arrangements. Because parliaments themselves must take responsibility themselves for protecting the rule of law, for protecting human rights, for ensuring that principles of good governance are applied. They are the most representative and legitimate of our institutions. They also are in a position to be the most effective on many of these questions because they can set the legal framework. So parliaments are in our constitutions, in most countries, uniquely well placed to actually be effective implementers of the rule of law and human rights and good governance, including judicial independence. So I think it's precisely the concern that Nico has described that for me makes it so important that parliaments must get more involved. And I think the reality is that we are still in the quite early days of parliaments working out for themselves what is our responsibility here? what can we actually do? What should we do which is going to help and show our commitment to judicial independence? Not because we want to control judges, which for me would be an illegitimate response to the democratic deficit. I don't share the view that we need to rein judges in. But what we do need is we need parliaments to actually ask themselves, if we're serious about the rule of law and judicial independence, what can we as parliamentarians do to entrench that in our society, to make it a part of our culture, and to make it an absolutely central principle of democracy. And that will help us to escape from this democratic deficit concern that is now extremely widespread. So for me, that's really the principal answer, I think, to the why parliamentarians should care question.
I have heard the rule of law, crisis of the rule of law, crisis and emergency of the rule of law taking place now. So never more than now, the subject that we are talking about has gained a critical importance. And your leadership, your thought leadership will be extremely important going forward in bringing all these different, doesn't matter which part of the world. And as you see, we're very, not only gender balanced, we are very well regionally balanced on this panel as well. No matter which region you talk about, the problems are there, but also the hope, I think, that people have in the rule of law, in justice, in the judiciary. And I mean, we've not answered adequately all the questions you have. We will have a reception now where please come, mingle with the panelists, and you may get your answers. But let me just end with a saying that the poor need the rule of law. The rich can take care of themselves. Thank you.